Avid Rebel watchers will know that the Whistle Stop Cafe was in court twice this week with the help of their lawyer Chad Williamson, paid for by the support of everyone at home through their generous donations to fightthefines.com and through our partnership with the registered Canadian charity, the Democracy Fund. Now, for those of you who don't know, and most of you already do, Fight the Fines is our civil liberties project where we put people in touch with top criminal and civil litigators at no cost to them to fight their lockdown tickets or summonses or court orders and sometimes even criminal charges in court at no cost to them. You can support that project at fightthefines.com, and your donations there now qualify for a charitable tax receipt. So that's good news. Now, getting back to the Whistle Stop. I said the Whistle Stop, and I guess the owner of the Whistle Stop, Chris Scott, was in court 2 times this week, first on a contempt hearing and then in the Alberta Court of Appeals. But let's go back briefly just a little bit. Give some history because there is a lot here. The Whistle Stop Cafe in beautiful Mirror, Alberta, population 500, is owned by Chris Scott. Back in January, he reopened his business in defiance of the lockdown restrictions on dine-in restaurant services. And the government just came for him. Tickets, summonses. Eventually, the government even seized his property, cutting the town of Mirror off from their only gas station and convenience store within 20 kilometers. Now, in May, the Alberta government went to court in secret and got a secret court order against Scott, restraining his ability to protest the things that the government had literally just done to him. The government went before a judge in Calgary without informing that judge, Justice Rook, that Scott had a lawyer, and they did this all without informing Chris Scott's lawyer, Chad Williamson, that there were proceedings against his client. All this to get an injunction enforceable with jail time to prevent Chris Scott from holding a protest at his now chained-up restaurant. So secret court orders in secret courts, and as a citizen, you don't even have the ability to fight back, as it turns out. Let me reiterate here. The government misled at worst or purposely omitted information from the court, then also failed to inform Chris Scott's lawyer of proceedings against his client. And the government, because of their sneaky bad actions, got that court order to stop the protest, but as you know, the protest went ahead anyway. Chris Scott was arrested. He spent 3 full days in jail for contempt of that court order. But before the protest went ahead, once Chris Scott and his lawyer became aware of the secret court injunction, they tried to fight it, but the courts refused to hear their arguments. So the government can sneak around behind your back, get court orders against you that result in your incarceration, and the courts won't even allow you recourse. So first, on Monday, Judge Adam Germain issued his ruling on charges of contempt and found Chris Scott guilty. We talked to Chad Williamson from Williamson Law earlier in the week so that he could explain everything that he was doing in court on behalf of his client. Let's start with the contempt ruling here.
In respect of the contempt proceedings, our interpretation of the court's ruling, which was handed down earlier this week, is essentially that all orders are to be followed, irrespective of any procedural irregularities. To a large degree, we agree with the court. People should not be allowed to just ignore court orders if they are irregularly given. However, in the exceptional case where someone's fundamental right to respond to proceedings against them, and where the sacrosanct duty of a lawyer to tell the court that the party they're moving against has a lawyer, we argue that contempt proceedings should not continue until such matters are heard. The impression we got from the ruling is that all orders must be followed no matter what, even if justice is delayed, even if someone's rights are violated. But how about if an order is the product of forgery? What about an order that is signed by a clerk instead of a judge? What about an order that on the face of it is invalid? I suppose we'll see, but we have concerns that the court has now closed the door to the principle of what we call reasonable excuse to disobey an order granted in breach of fundamental justice.
Friends, I know this story has a lot of legal jargon in it, and it makes it hard for a layperson to understand. I'm with you. I'm a journalist and a farmer. I'm not a lawyer. But that's why it's so important to have a project like fightthefines.com, where we have highly effective lawyers like Chad Williamson making these high-level arguments in court on behalf of victims of the lockdown. How is any normal person just trying to run their business or take care of their family supposed to navigate these complex legal issues without any form of help? Now, fast forward to Wednesday, Chad and his team were in front of the Alberta Court of Appeal, trying to get the court to hear their arguments about the problems with that first secret court order that the lower court refused to hear. And remember, because the lower court refused to hear those arguments, Chris Scott ended up in jail for 3 days. Take a listen.
In kind of a part two to this saga, we also appeared in the Court of Appeal this morning to appeal a very narrow point of law in relation to the lower court's refusal to hear what we call, and I've mentioned this before, our Gunn application. That is our plea, in light of the manner in which the injunction was given, that our client must have the right to be heard on the narrow procedural objection to the order. Of course, as soon as Chris was served with the injunction, we filed a hastily drafted but robust cross-application against Alberta Health Services, challenging the merits and the constitutional elements of the injunction as a whole. Our cross-application and the litigation in which it will entail is absolutely massive. Cross-examinations, briefs, multiple hearings, these things take time. But we requested that we be heard on the issue of procedural fairness right away. The court refused to hear our procedural argument and essentially lumped it into the main action. Now, that would take months to get through due to its complexity. This morning, we requested that the Court of Appeal overturn the ruling of the lower court that refused to hear our procedural point when we made it, which was urgent. Now, the courts generally have a broad degree of discretion as to timelines and process when running their courtrooms and when running matters. And that's a necessary function of the courts. But when the exercise of that discretion delays justice and ignores what we contend are clear infringements of procedural fairness, that discretion has not been applied reasonably. That's what we argued today, and that's why we're before the Court of Appeal. It's a very nuanced point, but it's extremely important. We want the Court of Appeal to rule on whether a person has an immediate right to be heard. Conventions of protocol notwithstanding, when principles of justice are in jeopardy. The Court of Appeal has reserved its ruling as to whether we even get to put this issue before a panel of appeal judges. So we'll wait for that ruling to come out. While Alberta Health Services argued during our application that our potential appeal has no general importance whatsoever, obviously we fundamentally disagree, and we'll see how the Court of Appeal rules and whether or not we'll be allowed to proceed to argue that point before a panel of appellate judges at the Court of Appeal.
Oh, but friends, you know there's more. There's always more. Chad Williamson is not done with the government yet, and it's pretty clear from listening to Chad there's a reason that the government didn't want Chad to be able to effectively argue against that court injunction when they were getting it the first time around. Chad and his team just had a process server hit Deena Hinshaw, Alberta's Chief Medical Officer of Health, with a subpoena. Take a listen.
Our process server served a notice of appointment on counsel for Alberta Health Services, setting a date for the cross-examination of Deena Hinshaw at the end of July. We've been trying to find a mutually available date to conduct our cross-examination, but to date we've not been able to reach an agreement with Alberta Health Services. Accordingly, we filed and served a notice of our intentions and seek to put some very important questions to this particular witness. We're exploring every avenue available in seeking relief for our client and seeking to uphold the principles that make this country great. The contempt proceedings, our narrow appeal on the issue of the use of judicial discretion, these are all subcomponents of a much wider action. Remember, the Court of Queen's Bench did order that the injunction matter be heard de novo. Now, what that means is basically it needs to be heard from the start. It's almost like a reset. Now, this will allow us to make a fulsome response to Alberta Health Services and explore our cross-application to have the court evaluate a broader set of issues that continue to affect all Albertans' justice, liberty, and fairness in this province. We're hunkering down, we're bristling up. We've got an arduous road ahead, but with freedom and justice as our banner, we hope to ultimately prevail.
So under Hinshaw's direction and based on her so-called medical evidence, which the government says that they need more time to produce. Chris Scott went to jail for 3 days. Either you have enough evidence of a danger to the public health to send a man to jail for 3 days, or you don't have it. But you better have that evidence before that guy goes to jail. Apparently, that isn't the case here. And let me just stop right here to make a point. Chris Scott held a 1,500-person strong protest against the government lockdowns. And there have been no outbreaks associated with that protest. And yet the health bureaucracy and the Alberta government in this province thought that what Chris Scott was doing that day was such a danger to the public health that they took away his liberty for 3 days and then put him in a facility where the province has been releasing offenders from because they're worried about the coronavirus inside that facility. Well, you know what? We're going to fight this thing with everything we've got. We're going to make the Chief Medical Officer of Health, Deena Hinshaw, explain herself and her reasoning for doing what she's done to not just Chris Scott, but innocent business owners and families. Business owners like Chris Scott, whose only crime is refusing to go broke quietly and politely at the hands of the government. The government is throwing everything they can at Chad Williamson and his team at Williamson Law. The government has limitless resources, but we've got you, and thank you to everybody who's donated to get us this far. If you'd like to help us in our mission to hold these out-of-control health bureaucrats accountable for the lives they've ruined with their lockdown restrictions, please donate today at fightthefines.com. And as I mentioned earlier, all your donations there now qualify for a charitable tax receipt through the registered Canadian charity, the Democracy Fund. For Rebel News, I'm Sheila Gunn Reid. The government has a mountain of tax dollars and resources to punish people for fighting back against the lockdown restrictions. The battle is uphill, the odds are stacked against us, but when people like Chris Scott stand up to the government, it's incumbent on us to stand with them. If you'd like to help us help people like Chris Scott fight back against the government, please donate today at fightthefines.com, and all your donations there now qualify for a charitable tax receipt through the registered Canadian charity, the Democracy Fund.